Many contracts contain a merger clause, stating that all the parties' discussions are merged into the written contract, or an integration clause, saying that the contract contains all the terms of the parties' agreement. Both are meant to establish that the parties have no other agreements outside the contract. In UAW-GM Human Resource Center versus KSL Recreation, the court considered whether a merger clause meant what it said. UAW-GM Human Resource Center, or Center, contracted with Carroll Management Corporation to use Carroll's resort property for a convention. During negotiations, Center and Carroll verbally agreed that the resort's workforce would be unionized. But the parties' written contract said nothing about a unionized workforce. The contract did, however, contain a merger clause, stating that the written contract merged all the parties' proposals, representations, and negotiations with respect to the contract's subject matter. The contract also contained a liquidated-damages clause, triggered if Center canceled its reservation. After the parties signed the contract, Carroll sold the resort to KSL Recreation Corporation, or Recreation. Recreation promptly fired the unionized workforce and hired non-union workers. In response, Center canceled its reservation and demanded a refund of its down payment. Recreation refused, keeping the down payment as part of the liquidated damages it claimed to be owed. Center sued Recreation for breach of contract and fraud. Recreation counterclaimed for breach of contract and enforcement of the liquidated damages provision. The parties cross-moved for summary judgment. The trial court granted Center's motion, determining that Recreation had breached a separate agreement requiring the resort employees to be unionized. Recreation appealed to the Michigan Court of Appeals, arguing that evidence of a separate verbal agreement was inadmissible under the parole evidence rule because of the contract's merger clause.